Okay, now we have the report called Regional Districts Utilizing BEN, page 162 to 207. Comments? I just note at the top of page 163, out of 28 regional districts, 7, including the Sunshine Coast Regional District, so 6 others, 1/4 are using BEN. And 2 of them, I note, are Metro and Fraser Valley. So it really isn't widely used in the regional districts. Director Seegers?
The other thing, though, on page 164, you can see that I know some of the directors here are saying they wonder if there's sufficient evidence in the, out in the wide world out there. Well, this has been in place for some of them since 2006. Right, so 2006, 2007, 2008, 2005. So if we're looking for, what the response has been, I think we can actually gather what we need.
Director Noor?
One thing missing on that, if you're looking at regional areas, there's some regional areas do not have building inspectors.
Director Lewis?
I know quite a number of the rural directors from the Caribou, and I asked them how they liked utilizing BEN. They thought I was talking a different language. They had no idea what I was talking about at all.
Yeah, I will note that when we brought it up at the electoral area meeting, everybody glazed over. The rural area directors didn't know what we were talking about. Director Moreau?
I do understand that it doesn't have 100% buy-in, but I always think of the logic of applying it, and obviously I know my area the best of all the areas, but in our case, MTI, in my opinion, is an unworkable system when you have to serve people that live in Los Angeles. It just doesn't work, so we have to do something about it. Otherwise, we're in my area, we're excluding about half the residences or half the construction in the area from ever getting fines. It's just not feasible.
Director Turnbull?
And I agree that the service issue is the issue because we have a lot of seasonal property owners. And from my point of view, that's what we should work on, figuring out how to get substituted service. I don't agree necessarily with the application of tickets day by day when the property owner may not even know about it yet. We stick it in the mail and who knows whether they get it. We don't know whether they're off for a 5-month trip or anything. And here we go, starting to have tickets and getting all upset because they're not paying attention. So from my point of view, the point is how do we get the attention of the property owner, not necessarily how we completely change our way of going about it by assigning fines.
Director Moreau and then Noor.
Yeah, I do understand that is an issue, and I certainly would be, and I actually wrote a note to a person asking the description of BEN. I think our policies on issuing tickets still do apply. Letters are written, people are warned, there's a whole process, and the repeat tickets are a big issue, and again, I think those kinds of warnings still have to apply, and we have to look at our policies to ensure that we fairly apply all of our policies. That being said, there's also, if it's a mailed ticket such as BEN, and MTI doesn't apply, but with BEN, there are mail and receipt provisions, double registered. I've just gone through an interesting thing at the Harbor Authority where we've had to use that on several occasions to get this boat arrested. So I think that there's processes that and policies that we do have to develop to make sure that it's fairly applied, but it's certainly an option that we can't close the door on.
Director Noor?
Peter, do you send a Ben ticket out immediately, or do you go through a process?
Madam Chair, what we do is we follow our bylaw enforcement procedures that have been endorsed by the board, and there are a significant number of letters that go out before we issue a ticket for land-based types of infractions. For animal bites and dogs running at large, we certainly don't do that because the response has to be more immediate. But for issues that are surrounding construction without permits, this type of thing, we do the letter writing regimen before we actually act on it. And in one particular case in Area B, we got no response at all with the letter writing, but as soon as a ticket was issued, the following week, the ticket was paid and cooperation was 100%.
Director Seegers?
Is there a process inside the Ben system we currently have for somebody who feels they were ticketed unfairly or they want to challenge the ticket? And what is that process?
Madam Chair, to answer that, there is a very structured system to deal with that. If to address Director Turnbull's concerns over somebody not receiving the tickets in a timely manner, if they can demonstrate that they didn't receive any mail, the screening officer can certainly deal with that and overturn the tickets, provided they can demonstrate adequately to the screening officer that that in fact happens. If they were away on a world cruise or something like that, they had no way of knowing that these tickets were being mailed to them. There is a process where if somebody feels that they've been unduly ticketed, there's a dispute mechanism and there's an adjudication process that can take place. So there are a number of steps to fairly deal with any resistance from an owner if they feel they've been unduly served, so to speak. And that hasn't happened. That hasn't been our experience yet. But there are mechanisms in place under the Ben system to allow for that.
That's for the amount of the fine, not just for the amount of the fine, right? That's the only thing that can be disputed.
No, Madam Chair. Actually, the issue I spoke with earlier was if you are certain that the person is not going to pay the fine, then you can register a notice of claim within the court, and that's where that situation occurs, where you can, it's not the amount of the fine, it's whether you can pay. Under the Ben system where that doesn't take place, you're just dealing with a screening officer, and if somebody disputes the ticket, then you can enter into a compliance agreement if there's a problem with payment. If they recognize they're guilty but they've been unfairly ticketed, then you can enter into a compliance agreement. Once a compliance agreement is entered into, it may only be the first ticket that is dealt with and not subsequent tickets. Or, in fact, if they comply with what the infraction was originally written for, there may be no ticket fines applied.
But you can't dispute the guilt.
No, you can't.
That's my point.
Yeah.
You can dispute the amount, you can dispute the ticketing, but you can't dispute the guilt.
You may be guilty, but there are certainly ways of dealing with how, whether or not a ticket is applied or how many tickets may be due and payable. And that's built into the system to make it more fair for the recipient.
Director Turnbull.
Yeah, from my point of view, what is the flaw here is I understand the whole point about the screening officer, the discretion, etc. And from my point of view, the issue is exactly what Director Sugar brought up, is once the screening officer decides you're guilty, then any appeal to our people who come that we ask for, it's not about guilt. It's about, you've already got strict liability, and it's only about the amount of the fine, as I understand it. So from my point of view, that's a very internal mechanism that doesn't have checks and balances.
Director Noor.
Can I ask Peter another question? During the process of going to the property, sending out a letter, those sort of things, the person's got a chance to appeal during that time before a Ben ticket comes out. Is that correct?
So what about sprinkling regulations? How do you prove guilt on that score?
The way that Ben is applied under the sprinkler and irrigation regulation, it's similar to the dog running at large or the dog bite. It's based on the balance of probability. If you're a property owner and you have your sprinkler running and it's outside the permitted hours of operation, somebody in the house turned it on. So if there is an owner involved, that person gets the ticket. If it's a tenant involved, then the owner will probably pay the ticket on his behalf, but he may not be a tenant there much longer as a result.
Okay, I think we've beaten this one to death. Let's move on.